Good afternoon and welcome everyone to today's webinar. In these unprecedented times, home working has become more normal and has reshaped the world of work. Many employers and employees have seen the benefits of home working, and as such, many employers are planning to or already have adopted flexible and hybrid working to meet the challenges of the post-COVID world. However, it's not without its challenges from an employment and data protection perspective. So today we'll be talking about and hopefully answering your questions on flexible and hybrid working, the challenges posed, and providing you with some insights on how to respond. My name's Hannah Moran and I'm a solicitor within the commercial team, and I'll be chairing the webinar today. I'm joined by my colleagues Padma Tadi, who's a senior associate within the employment team, and Joanne Bourne, who's a partner in the commercial team specialising in data protection and GDPR. Just before we start, I'll just highlight a couple of housekeeping points. If you've been to one of our webinars before, these will be familiar to you, but if not, and as a quick reminder, if you've got any questions during the webinar, please submit these through the Q&A box. We'll try to answer as many questions as we can throughout the webinar, but please include your email address. If we don't have a chance to answer them, we can get back to you afterwards. There's also a feedback form already in the Q&A box, but it'll be posted throughout the webinar and at the end. So if you've got any feedback, we'd love to hear from you. Just let us know and complete the form. That's all from me at the moment, but I'll pass over to Padma now to start talking about flexible and hybrid working.
Thanks, Hannah. So James, if we can move on to the next slide, please. As Hannah says, the first thing that we'll cover off today is flexible working, because I think certainly from my practice and the clients that I'm seeing at the moment, we're starting to see that increase creep up in terms of flexible working requests as we return to normal. People having sat through a pandemic, balancing work, home life, and some people have seen the positives of it. For some people, they're raring to get back into an office. So I think the first thing, as I say, to touch upon is what to do in a flexible working situation. The main thing to point out is that the pandemic and COVID hasn't changed the general principles of flexible working and the law itself. So as a reminder on the slide, here are a few eligibility criteria of what people need in order to make a flexible working request. So that is that the request is made by employees with at least 26 weeks service, only can make one application in a year, and there's a process to follow, which I'll come on to in the next slide. But ultimately, the responsibility is as you as the employer, that if you receive a request, that you are reasonable. It doesn't have to be perfect in that sense, but what you would need to demonstrate is that you have thought about what the individual is asking and why you can either grant it or not grant it, or whether there's any other middle ground that can be reached to satisfy what it is that the employee is looking for versus the concerns and challenges that you have. Now, I know that several of you joining us today are IMHR Plus clients, which is a fixed fee retainer that we have within the employment team. And if you are one of those clients that are watching today, then if you go onto the portal that you have access to as part of that retainer, we have updated and put a load of documents in there that relate to looking at flexible working requests, your flexible working policies, and how to address those. And because it's a topic in itself, I only want to cover it off with the most salient points today. But if you are interested or you do have any further questions in terms of that process, then please just fill that out in your feedback form, and we can send you further information in relation to that too. But otherwise, as I say, the main thing to look at is nothing has changed in terms of what you were previously doing in relation to flexible working requests. It is just simply that you might start seeing more of them. And the other thing to point out with flexible working requests and even looking at granting them, you've got to remember that once it is granted, it is a permanent change to contracts. And therefore, you need to then think about, is a flexible or a rigid flexible working request the right way to go about this for what might be a temporary change? So is it that people are thinking, I do want to return back to the office, or I am able to return back to the office, and this isn't something that I want longer term, It is just that I want to see how things pan out in terms of the vaccine data, children going back to school and those types of things. So again, think about whether you're balancing things out and whether it's right that you're looking at a permanent and rigid flexible working request compared to a flexible, a more informal flexible policy, which I'll come on to in a second. So if we can move on to the next slide, please. If you receive a flexible working request, the other important point to note is that it doesn't mean that you have to grant it, and the request does not automatically mean for the individual that they have a right to receive it. Ultimately, with every flexible working request, it's about that dialogue with the individual and understanding where both parties are coming from to see whether it can be something that is accepted. One thing as an employer that you need to be slightly careful of is that if it has worked during the pandemic, given that overnight pretty much a lot of employers had to switch to working from home and remotely, and that has worked, you now need to work that little bit harder to understand or be able to turn down that flexible working request if it has worked. Now, just because you have granted it in unprecedented circumstances doesn't equally mean that you have to then grant every request that comes through, because for some organisations what it's meant is you've survived with remote working during the pandemic. So it might be something that you've said, yes, we've allowed it, yes, we've been able to do it, yes, we've been able to set up systems, but it wasn't the perfect thing. And now that we are coming out of lockdown, out of those restrictions, actually we need to start returning back to something that we were previously seeing. So really, what you need to do is a fact-by-fact analysis, looking at your own industry, your own sector, your client base, and what you need to be able to justify if you are turning down a request. And as before, there are 8 statutory reasons as to why you can turn it down, which again has a full range, which I'm more than happy to share with you those in more detail later on if needed. But just think about those that are there. And also, when turning down requests, just have a little think about what the reasoning is that the individual is giving you as to why they are requesting that change. So, for example, as highlighted on the slide, childcare disparity is something that is still very much recognised by the tribunals. And what I mean by that is there has been recent case law that continues to affirm that a tribunal will accept that women tend to have more childcare responsibilities, and therefore if you have requests in terms of changing hours because people say, well, actually what we've been able to do during lockdown is take children to school, pick them up, etc., and that is something we want to continue doing, you need to think about that in terms of the request and whether or not that exposes you to a sex discrimination claim. Now, again, it may be that your own sector circumstances mean that you still can't grant it, but the fact is you need to think about it and look at whether there's any other solutions to the challenges and concerns that you have before automatically turning something down. And the other thing to remember is that when you get a flexible working request in, it is not necessary for you to ask or for you to know exactly what the reasoning is as to why someone is asking for a flexible working request. Albeit you tend to find that employees tend to share with you the reasons, such as childcare or reasonable adjustment by way of disability. But ultimately, individuals, even without any of those responsibilities or protected characteristics, for own personal reasons, can still make that flexible working request. And you have an obligation to look at it reasonably, because failure to do so and failure to follow the correct process could leave you exposed to a claim which results in compensation of up to 8 weeks capped pay if there is a successful claim there. So just moving on to the next slide then. As I said, there is a set process to follow, which is done within a 3-month time period, which in a nutshell involves consulting with the individual. And as I've said, there are penalties there. But ultimately, you need to think about, is it something that you are wanting to do on a more permanent basis, or you're being asked by employees to look at on a more permanent basis? or is it something that is a bit more flexible? And so on the next slide, I'll come on to a trust policy, but ultimately what you need to think about is it something that can be quite fluid and subject to change? And it's one of those things that it's sort of opting in and out, or something that as an employer you want to offer as a flexibility. I probably would think about not using the formal flexible working policy for a permanent change, but look at your general policies and to see what communications you want to put out to staff and how that will work, setting boundaries and expectations of how it will work depending upon departments within the organisation, or it might be something that you can deal with as an organisation as a whole. So moving on to the next slide, please. As I say, you'll have two options. You've either got a flexible working application that's formal under the same policies that previously applied pre-pandemic, in which case, because it is a permanent change, you will confirm those changes in writing, because that is a Section 1 of the Employment Rights Act requirement, and you must do that within 1 month of the change taking effect. So that can just be a simple letter rather than a full contract being reissued, where you're setting out if there's changes to pay or hours or place of work, that you're confirming what those changes are within each of the clauses. But I also mentioned that a lot of employers, us included as a law firm, we have gone to a trust flexible agreement. And what that means is that is more about saying, actually, we recognise that you can do your work anywhere, anytime, and therefore we will trust you and we value you as employees to be able to manage that as long as work is delivered within certain parameters, in which case you wouldn't want permanent changes in writing, but what you'd want is a policy which sets out the boundaries. So it might be, we trust you to work as long as you do your contracted hours, but there will be still core hours between 10 and 4 o'clock, for example. But beyond that, if you wanted to start earlier or finish earlier, we will allow that. Or even if it's will allow you to work from home or come into the office whenever you want to do that. There's no minimum or maximum, or there might be minimum and maximum, and you can set that out as well. But you also may want to put out in that policy information around, well, you will still need to come in if there is a team meeting that is important for you to be at, or there's a client meeting, or there's a customer sales meeting that you need to go to. So with the Trust Flex agreements, it's more about thinking of what your needs are as an organisation and setting those boundaries. But otherwise, what the pros of this is that it's not a permanent change. You can always then flex it as things move on, or if you find that things aren't working. And it also gives that level of trust and builds that rapport with your staff to feel valued. And that is a big USP at the moment for most employers, if individuals are looking to move around and those types of things as well. The con of it potentially, and again, Joanne and I will come on to talk a little bit about employee monitoring and looking at productivity, is that con of, does it actually work, and does it then lead to individuals who are potentially being lazy or not doing what they should be doing or not being responsive? Is this a mechanism in which they can hide under to not necessarily fulfill all their duties? But that's where you need to then think about that if you do have those issues, of what ways can you monitor and look at staff to ensure that productivity, which, as I say, we will come on to in a second. I guess a couple of other points that I just wanted to make before we do turn on to sort of looking at managing staff remotely is, as I say, think about what your organisation wants to achieve and whether it's a permanent or a flexible thing. Also think about if it is that you want to allow, or you are being asked to look at this as a permanent change for staff, you need to do a bit of road mapping to see whether it's something that your organisation as a whole can achieve. So what would you do in those circumstances if the whole team come to you with a flexible working request and everyone wants a Friday at home? Does that work? Doesn't it? So again, I think ultimately as HR professionals or directors or whatever your position is and reason to be on this call, is think about that road mapping and think about the different challenges that could come your way so that you're not then left in a position of saying, we'll look at flexible working requests from everyone, start granting them, and then you're left with people saying, well, you've granted so-and-so a flexible working position, but now you can't accommodate me. So again, just think about what that may look like for your organisation. And as always, we're more than happy to help you with some of those business plannings if that's what's needed. So to move on to the next slide, unless Hannah, I don't know whether you want to just ask or see if there's any questions that have come in from a flexible working point of view.
Yes, of course, we've had a couple. So one question we've received is in relation to the one application that can be made per year. Would applications be able to be made more frequently if the employer is happy with them to be made?
Absolutely. So the statute is 1 per year, and that tends to be, or historically, that's something that employers welcome, because you tend to find that people will carry on giving it a go. If you've said no once, then they'll just change it slightly, carry on adding to it. But if as an organisation you're willing to accept them more frequently, then absolutely. But I think that'll come down to the size of the organisation and whether it's something that you can manage administratively, because if you then think you've got 100 staff and they've then got an opportunity to make an application more than once in a year, you might struggle with just going through the general process and then having to do all the bits that go with it.
Perfect. And then we've just had a couple about the trust flex agreements. So there's one that says, would the contract still need to state that the work location is the office address 5 days per week? Or could you put something else in?
I think I've been working with a few clients really to say your main base of work is the office and you are expected to come into the office as needed. However, we also will allow you to work from home from time to time, as set out in further detail in our Trust Flex policy, or whatever you've decided to call your policy. So you can give a nod to it from that perspective. For existing staff, if that is the only change that you're going to have, I wouldn't worry about issuing a full new contract. What I would probably do is issue a memo or a side letter that goes out to staff with some records to show who you've given it to and who's accepted that, to say, Clause X of your contract will traditionally say this. As we've learned from the pandemic and as we move forward, this is what we're now agreeing to. So that would suffice to do a simple letter with a one-liner referring them to that Trust Flex policy.
Perfect. I think that's all the questions we've had for now. So I'll pass back and you can carry on with the presentation.
Thank you. One other thing that I have seen come in actually is about whether the Trust Flex policy needs to be written and do we have one? Yes, we are more than happy to look at that with you, and we do have some templates that we can provide. So in a few slides, I will come on to an agile toolkit that we do have as a firm, so I will pick that up then. So looking at managing staff remotely then, again, the same disgruntled employees? Are you keeping in touch with the individuals, setting those expectations, the normal boundaries of professionalism, and still stay? I think the difficulty, and something that I think Joanne will probably come on to as well, is when we're in our using platforms such as Microsoft Teams and just sending off quick chats, things become a lot more informal. And so what you tend to find is that's where you have lots of slip-ups, but obviously those chats, etc., can still be recorded, screenshotted, etc. So that's where people need to remember that in the workplace, despite using all the different mediums that you have compared to the traditional letters, emails, where we've become used to still maintain that professional boundary, that professional boundary is still expected in things like WhatsApp messages and all the different other social platforms that you may use. So one thing that I would probably recommend is looking at your policies around social media, email usage, or other electronic communications, and make sure they're updated with all the new platforms that we've started to see. But also in terms of remotely managing staff, and as I say, despite nothing changing, one thing that is easier, and I've seen with a lot of clients happening, is it's easy to forget that people are still there and working if they're not in your eyesight effectively. So do remember that if you've got managers and anyone in managerial roles, that you're still taking that time to set some time during the week, that you're still catching up, you're giving that person a call, you're setting in a Teams meeting just to check in, so that you can be supportive in terms of people that might be struggling, particularly with mental health. And that goes to other avenues which are probably outside of the scope of today, in terms of things like reasonable adjustments for disabilities and those types of things. So think about what are you doing to keep in touch with those staff and to carry on maintaining that dialogue and relationship. The other thing is, as I say, think about how you're managing remote meetings, and think about when you think about what that looks like and who's party to it, and that you're still continuing to have those meetings. Moving on to the next slide then, as I say, set regular objectives and regular reviews with staff, and use all the different communications that are out there. And maybe again, this is another road mapping, team planning type thing, to understand how is it that think about, yeah, as I say, whether people prefer different types of communication, different ways of working, and just resist the urge to micromanage, even through teams and success. So just moving on to the next slide then, let's see what Joanne has to say in terms of a GDPR perspective and sort of monitoring staff remotely. Oh, Joanne, you're on mute.
Oh, you'd have thought I've got that sorted by now, wouldn't you, after all this time? Sorry. Yeah, monitoring, it's an interesting one from a data protection point of view. And I think because technology is moving on, it is something that we're seeing quite a bit of. Now, today we're just going to scratch the surface of it because it is quite a big topic. And if anyone is interested, if you can put it in the chat, and Padma and I will have a look at it as a separate topic. We're planning on doing something on that. I think as Padma says, because people aren't in the office, and potentially if you're running a team, you might not know what the team is doing, or you might not know where people are. There has been a bit of a tendency during working from home for people to start to use new technology to monitor what people are doing. So this could be, you know, looking at what sort of how much time people are on the phone, checking telephone messages, voicemail messages, looking at the amount of internet usage, and certainly internet usage and sort of blocking certain websites has been very common for some time. There are some other things in terms of the, you know, sometimes people are wanting to use webcams or even checking keystrokes of staff. So I think one of the things you need to bear in mind if you're wanting to do something like that is to think about the data protection aspects of it, and it is something that the ICO has commented on. It's also something that the European Data Protection Board, who's the European equivalent of the ICO really in terms of issuing guidance, has also commented on, and it's also something I suspect will be picked up in the new version of the ICO Employment Practices Code, which is currently under consultation as to what is okay and isn't okay from a monitoring point of view. So I think the crux of it from a monitoring point of view is it's got to be, as I've said on the slide, it's got to be necessary, it's got to be proportionate, and it's got to be justified. So you need to think long and hard about what are you trying to achieve, and in terms of the technology that you're planning on deploying, is it the right thing to use to get you where you need to be? Because if there is a less privacy impactful solution, then that is something that you might want to think about. Because I think one of the other things that needs to be factored in is that, you know, if you've got somebody on permanent webcam, it is their home where they're working from, and so there is an element of intrusivity, and you know, it's intrusive from a privacy point of view in terms of seeing into their home. So in terms of, you do need to think long and hard about what you are wanting to do. Having said that, it is also accepted that certain levels of monitoring are okay. and that there are some justified reasons for monitoring. I think one of the best ways to think about whether or not what you are doing is necessary and justified and proportionate is to think about whether or not you need to do a data protection impact assessment. So a DPIA, as it's shortened to, because we lawyers do like our acronyms. So a DPIA is essentially a risk assessment where you have a look at what you're planning on doing, and then you have a look at the privacy impact of what you're doing. You have a look to see whether or not the two are balanced, whether or not what you're doing is lawful under Gdpr, whether or not you can justify it from that point of view, how transparent it is, and then you come out at the other end with essentially a risk profile related to it. I would probably suggest that if you are going to start new staff monitoring, you strongly think about a DPIA. It's compulsory in certain circumstances, so that if it is essentially use of personal data that's high risk, so that if you are potentially going to be monitoring a publicly accessible area, so for example CCTV, or you're going to be doing systematic or extensive monitoring of employees via an automated method, then it is something that you should be doing and you have to do a DPIA. The other thing I'd say is don't avoid it. It's quite useful. It does flush out some things you might not have thought about from a risk point of view, and certainly have seen clients when they've gone through it and suddenly they come out with something and they realise they've not really thought about it. So I would strongly advise you do that. The other thing from a monitoring point of view is certainly the ICO's expectation is that apart from in very limited circumstances, so for example, if you are concerned that, that maybe there's some theft happening and therefore you need covert monitoring, all monitoring should be transparent. So one, people should know, for example, where the CCTV cameras are, as I say, unless you've got a really good reason for them not doing. And also you should be very clear about your monitoring in terms of there should be a reference to it in your policy documentation, and also in your employee privacy notice. Again, you should be clear about what monitoring is happening and how you're using the information you're getting from the monitoring to comply with your obligations about transparency with your employees. So as I say, that pretty much scratches the surface of monitoring, but just to flag that there are quite a few data protection issues relating to it, and so you do need to factor those in if you're going to start a new monitoring program. The other thing, just before I hand back to Padma, back to something that sorry, I just remembered that something Padma said that I did want to mention in terms of during the pandemic. Obviously there have been more informal methods of communication. We do see that quite a few data subject access requests made now in the employee context, in terms of if there's disciplinary or if there's a grievance or something of that nature. And if you have used these alternative methods of communication and you have been very informal in them, you may find that they get misconstrued because they are not outside the scope of a Dsar. In terms of if you've used WhatsApp, it's not outside the scope of a Dsar, and if you've been joking or there's been banter, doesn't always play out well when it comes out on a Dsar. So do just bear that in mind in terms of the more informal method of communication. So Hannah, I think there have been some questions that have been coming in.
Yes, we've had a couple more questions come in. I think they're more directed at Padma than they are at you, Joanne. So one question we've had is, what would you suggest in terms of salary adjustments if employees are working flexibly or as part of hybrid working, particularly if they were previously based in locations such as London?
I think it's a really interesting one, and it's certainly been covered by the media a lot, because I think we've had a few MPs and ministers talking about removing London weighting and those types of things. Now, I don't think there's anything formal out in relation to that or any specific guidance that we can refer to yet, but it is certainly something that I think a lot of employers are starting to look at, and I think it's one of these watch these spaces type scenario. In terms of salaries, though, I don't think what you can suddenly go around doing is to say, actually, we're asking you to work from home and therefore we're going to start cutting your pay. ultimately that is a change to terms and conditions, and so to reduce anyone's salary, regardless of what the reason is, you are going to have to consult with staff and follow that formal consultation process, which again is probably outside the scope of today. So just be careful to not unilaterally sort of go in and start implementing something of that nature. And I think it's also a balancing act, which isn't really a legal thing, but more commercially, of how is that going to impact the trust and confidence that you have with staff, and are you going to then retain the right calibre of staff as well?
Thank you. Another one we've had is, do you have any suggestions as to how businesses can practically log employee working hours now that hybrid working has been introduced?
It's a really difficult one, but I think what a lot of employers have missed from conversations that I've had is there's always been an obligation under the working time regulations to monitor the hours that your employees are working for the purposes of rest breaks and health and safety and those types of things. So I think it will really depend on your sector and the type of employer that you are, whether that be using a clocking in, clocking out system if you're a factory type setting, or is it that you ask people to record and log their hours on some form of HR type portal? But again, you need to look at balancing that out without appearing to be Big Brother and sort of explaining why you're asking them to do that versus you know, explaining the downsides of it. But I don't think there's an easy solution. I think it's something that needs to be looked at depending upon your sector.
Perfect. Joanne, we've just had a quick one for you. Please, can you explain what a Dsar is?
I can, and also I think there's another one that's sort of related to what I said about Dsars. So Dsars are data subject access requests, or subject access requests as they were well known pre-Gdpr. And so essentially somebody wants you to provide all their personal data or a subset of their personal data. So regularly, as I say, it's used as a fishing expedition as part of if there's a sort of an employment issue, we regularly see it. In terms of what I was saying about WhatsApp and private communications and things, it's an interesting area, and it gets interesting. If it is essentially a work issued device, then I think it's going to be very hard to argue that you wouldn't have to look at text messaging or WhatsApp messaging on a work issued device if it potentially relates, because it's the equivalent of a laptop. If there have been messages that have been exchanged in relation to an employee who wants to know all the personal data that is being held. If it's in relation to somebody's personal device, then there are certain circumstances where you are required to ask somebody to have a look on their personal device, and that's if essentially you suspect that they have been using it for the purposes of the business and in relation to the individual that wants access to their personal data. So you don't generally have to go around, if you get a subject access request in from somebody, to ask everybody to check their personal mobiles. But if you think that, so for example, you know that somebody uses their personal mobile for both personal and for business use, then you know, it may be something that you think that there have been an exchange of messages. It's a very, it's a tricky area. I think all I'm saying is that, and I know that you can't legislate what staff say between themselves, but for example, if there's a team or there's a management team, don't assume that you can exchange messages on WhatsApp and you can say what you want about somebody without it potentially coming to light, is all I was really saying.
I'd echo that, Joanne. I've had a few cases over the years where at board level, people are sort of sending what they think are private messages, which then come out in the wash through disclosure or a subject access request, and they can be quite damning. So yeah, always be careful about putting things on any format whatsoever, because you know, you never know. And some of these things in terms of WhatsApps, again, some of the cases that I've had over the years, it's sometimes the perpetrators and people that have been involved in it that for whatever reason partway through then want to take a step back, and then the people that sort of then go to their employees say, here you go, I appreciate I said this and this, but I'm remorseful for that now, but here's the continued sort of set of circumstances of what's gone on. So again, just something to be really really careful about. I'm really conscious of time because it's great to see lots of questions come in, and we really want to try and answer those. And also Joanna and I have tried to pack a lot in terms of what we're trying to deliver today. So one thing to say is, if you're asking a question, if you could put your name as well, only we can see that it's you that's asking that. So please don't worry about the questions you're asking or that it's linked to you, because what we will do is, if we don't get to the question that you've asked, then we'll try and do a follow-up with you and sort of answer those. So we don't want to get those missed, or we don't want to miss them if we don't get round to it. But on that note, if we can move on to the next slide, I will just do a quick counter through lone working. And as I say, I will sort of counter through this because I think we're coming on to vaccinations and what that means for office life as well, which I think will be quite an interesting topic for several of you. So lone working, I think, in a nutshell, what I want to cover off in the next few slides is that ultimately, just remember that all of us moved pretty much overnight into home working, and that was just needs necessitated it. Now, depending upon what employer, what industry you're in, you're going to start looking at working flexibly and having that as a continued model moving forward. And as part of that, just remember to engage with whoever is responsible for health and safety within your organisation, or external professionals if that's what you use, to make sure you're still compliant with those pieces of legislation and those risk assessments. So just because someone is a lone worker, it doesn't mean that they are completely absolved or won't have the same hazards of physically coming into an office each day and potentially having a trip or a fall over a wire or something else in an office space. It's just a different type of risk that they may have. And a risk at home possibly is more mental health related in terms of stress, not having anyone to turn to, and those types of things. So I guess my plea in relation to these next few slides is just remember, as we're moving into this new world of working, just revisit your risk assessments and making sure that you're looking at it from a home working point of view and also on an individualised basis. So you need to think about or identifying who might be more vulnerable. So again, going back to remote check-ins and seeing if your staff are okay and what's going on. Think about that from a mental health point of view. Or is it that they are extremely young? So there's quite a lot of people that may have been working in a one-bedroom flat, in a flat share and those types of things. So, you know, are they okay, and do they have a proper station to work at, and what should and can an employer do in those types of situations? Because again, you will have obligations to look and assess those types of things. Same with pregnant and disabled staff as well, in terms of making those reasonable adjustments and making that a safe workplace. Now, that doesn't mean that you necessarily, just moving on to the next slide, that you have to physically go into people's homes and sort of demand to look at, you know, what their workstations are at, like, and what they're doing. But think about whether you can design a questionnaire that's relevant for your organisation and the types of works that those people do, to maybe do a checklist to say, you know, are you sat at a desk? Do you have a comfortable chair? Do you not? What's going on? And asking those types of questions. And as I say, it's not only the physical aspects you need to be looking at. The first bullet point there is looking at things like stress management. And again, if you put on your feedback forms, I'm more than happy to share with you some of the information that are within these codes. But they give various factors, such as you should look at demands, such as workloads, work patterns. What impact does that have on your staff? Look at control, you know, are you directing and supervising them to the level of support that they need? What type of role are they in? Are you promoting that positive workplace environment despite people being sat in different locations? And also just understanding, do they feel that they've got enough supervision and those types of things? So there's lots of different policies, which, as I say, I've got a bit of a checklist that I'm more than happy to share if you want to put that on your feedback form, and we will get in touch with you, where it's got some checkpoints for you to think about, such as supervision policies, and just runs you through some of the things that you might want to revisit and that might need revamping in a post-pandemic world. So moving on to the next slide, please. As I said, just think about also just looking at workstation assessments. As I say, you can do that remotely. There are some tax implications in terms of if you're contributing towards costs, so make sure you're engaging your accountant in relation to that. And then the next point, I think, is something that I'll probably invite Joanne just to come in and say a little bit about, but also just thinking about whether you need to be setting other policies that if you are going to continue to allow people from working from home, or as I've seen, so I'm in physically in one of our offices today, and I nipped out at lunch, picked up a coffee, and saw loads of people sat around with laptops working, which again I think is going to be a very common thing. But one thing it automatically made me think is I can see over that screen whether that person or what they're working on, is that really confidential, or is someone about to pick up the phone and have a confidential call? Are these people, do they have directions and expectations set by their employers? Because it's not necessarily something that we all automatically think about. So equally, as I say, I'll just invite Joanne to come on and say what she thinks from a GDPR perspective, but certainly from my perspective, again, revamp your policies to set those expectations and what that should look like.
Yeah, Padma, I think it is something I'm going to talk about in a minute in a quick canter through, which is security obligations. One of the things that I think you do need to think about from a flexible working point of view is where people are working and is it secure in terms of are they going to be disclosing personal data? Also, you know, potentially from a regulatory point of view, like we've obviously got client confidentiality obligations. If you're in a regulated environment, you've got that as well. So I do think being overheard and potentially, you know, providing what you can to help with that. So like headsets or something of that nature, so that, you know, anyone can only ever hear one side of a conversation, requiring people to use it or to go to a private location if it's something that is going to be sensitive. I think they're all things that need to be quite carefully thought about.
Thank you, Joanne. So just moving on to the next slide, I just quickly wanted to mention that I know that I've said that several of you on today's call, I know I'm HR Plus clients and will be familiar with some of this information that are on portals for those types of clients. However, if you're not, just to point out that we do have several toolkits, so we've pulled together an agile and hybrid toolkit and flexible working toolkits, which you can purchase just as a one-off, even if you're not a retaining client. So again, if you're interested or want to know more about that and what that would look like for your organisation and how that would work, then please do get in touch and we can talk you through and supply you with some of those toolkits that we've put together that we've had some really good feedback on of them being helpful for organisations. So I'll hand back over to Joanne to just carry on talking about data protection and home working.
Thanks, Padma. So if we can move on to the slide past the picture, that would be great. I am just going to quickly canter through because, as Padma says, we have got some very topical stuff relating to vaccination status that we do want to get through. So this will be a whistle-stop tour on working from home and data protection and security issues. I think I'm just going to come back to what I've just said in terms of just because people are potentially working from home or working on trains, working in coffee shops, things of that nature, in terms of the flexible by choice sort of side of things, you can't ignore security issues, and you do need to make sure that you meet the requirements of GDPR in terms of from a security point of view. Now, GDPR is relatively broad brush when it comes to security, so it doesn't give you a list of things that you have to hit. And what it basically says is that you have got to have appropriate security measures in place, both technical, so looking at your IT side of things, and also organisational. So again, you know, locked doors, locked cabinets, accessible, who can access things, etc. In terms of, and it's got to be appropriate to the data we're talking about. So the more sensitive the data that you have, the stronger security requirements that will apply from a data protection point of view. So there is also a list which sort of says that you need to think about what's market, what state of the, you know, in terms of what's the state of the art. It doesn't have to be cutting edge, but it does have to be kept up with what people would expect in your sector and the sort of data you're talking about. Looks at the cost of it. Again, if you're not essentially processing really exciting data or sensitive data, then you can argue that it's a lower risk and therefore you can have a lower level of security and therefore cost impacts upon that. And I think the thing that is crucial, as I keep coming back to, is the type of data that we're talking about, and it has to be security that's appropriate. So as I say, you can't just throw all that out of the window with working from home. And I think if you are rolling out new technology to facilitate working from home, or certainly rolled it out when the pandemic started, you should take a long look at it to make sure that it does meet the GDPR information security requirements. I think the other thing to think about, moving on to the next slide, is that there are some overarching provisions in GDPR that quite often get swept aside when people sort of dig into the detail of GDPR, and one of those is data minimization. So again, I think one of the things that helps with security is data minimization, because if you think about who should have access to what data and limit who gets access, then again that helps with security. It also helps with data breach. Because I think one of the things to bear in mind is all these things are interlinked in terms of having the right security is something that will be looked at and put under the microscope if you have a data breach. And so the more appropriate your security, the less likely you'll have a data breach, and the less likelihood that you have to go to the ICO and tell them sort of cap in hand that unfortunately you've had a data breach. Encryption is something that the ICO and certainly GDPR is keen on. It is quite a useful tool in terms of from a security point of view. The other thing to bear in mind is staff training, and I think it's back to the point that Padma was making in terms of if you're rolling out new technology, people need to know how to use it, because one of the things that we see that can lead to data breach is where people decide to come up with their own workarounds. So they don't really know how to use the new technology, and so between them they come up with a way to sort of work around it, or to put things in areas that are not secure because it's easier to access it, because getting into the secure area is quite difficult and it's a pain. So I think you need to train people, you need to have policies around it to make sure that people aren't coming up with their own workarounds, because that very often leads to trouble, certainly from a data breach point of view. Moving on, specifically looking at new technology, I think one of the other sort of flip side of the security thing, which is something I have already mentioned, is new technology. A lot of people are rolling out new technology now, have rolled out new technology when the pandemic hit. And in addition to the security things, I think the other thing I would flag with you, and again, I'm not going to go into a huge amount of detail because we don't have a lot of time, and I want to get on to the interesting side of things from a vaccination status point of view. But there are some requirements under GDPR in terms of if it's high risk, in terms of the nature of the new technology, in terms of the processing of the data, you need to do a DPIA, which we've already talked about. You need to understand what the data flows are, because there are rules in terms of in GDPR and also ICO guidance rules about data sharing. So if there is going to be any access to personal data, so that could be a cloud arrangement, could be hosted arrangement, it could be from a support point of view. If your supplier can access the personal data that you have on your systems or through the new technology, you need to understand that, and you need to do an analysis in terms of on what basis are they getting it. Are they your processor? So essentially there's somebody that does as they're told with the data, or are they a separate controller so they have some autonomy around the data? And the reason why that's really important is because the ICO has issued a data sharing code, so that there are rules in there about what you've got to document in any agreements where you're sharing personal data. And also under GDPR itself, if you've got a processor arrangement, so moving on to the next slide, so if you are the one that decides what data you are collecting, but you've got somebody you're delegating, say hosting, to somebody else, they're a processor. In Article 28 of GDPR, there are some things that you have to include in your contract with any processor. So you do need to understand from a contract point of view what role they've got. The other thing that I'm just going to very briefly flag with you is that if you are a bit confused as to what you might have to put in your contract from an Article 28 point of view, because certainly you'd have thought in terms of when there's a list of things in GDPR that a lot of contracts would look the same in terms of pulling that list into it, but I have seen certainly contracts that go from a couple of pages to War and Peace. So certainly Article 28 gets it's interpreted in lots of different ways, but the Commission has issued some non-mandatory clauses which are standard clauses for meeting requirements under Article 28. Now they are European, but they're broad enough that they will meet requirements from a UK perspective as well, obviously because we're no longer in the EU following Brexit. Now, the other thing I am just going to flag with you, because I've done a whole webinar on it, is data export. If, for example, the personal data you're talking about is hosted out of the UK or out of the EEA, you need to know, because there are lots of hoops to jump through in relation to that, and in particular if it's going to the US, where there are all sorts of issues following on from a court case in the summer of 2020. Now, if anybody is interested, if you let me know, I have done a whole webinar on the current position in relation to data export, so I'm happy to sort of send you to it. It's on YouTube, or if you want to raise it with me, and I'll email the link to you. But certainly data export, understanding where your data is absolutely critical with any new technology. I think the other thing that I would just say is that you also need to, moving on to the next slide, update your documentation. So as Padma has said, you not only need to update your policies and things from an employment point of view, but if the new technology or the working from home impacts from a data point of view, you might need to update in terms of your security policy, your acceptable use policy, things like that, an employee policy, and also you need to be very clear with people how you're using their personal data. So you need to also have a look at your privacy notices. Now, I appreciate that's a whistle-stop tour, but I want to pass back to Padma to launch into vaccination status.
I'm on mute. The other thing that I should quickly just mention, in your feeds, someone will post our LinkedIn profiles, and what I would also suggest is, if you want to, and you have a LinkedIn account, do think about linking with Hannah, Joanne or I, because we do regularly post things, because I think a lot of what we are talking about is something that is still subject to change, subject to further movement, opinions, cases that are starting to come through, and we regularly tend to post on our LinkedIn profiles with views, opinions and updates. So do link in with us if that's something of interest. So as Joanne says, we'll just quickly finish off with vaccinations and where we currently sit with it. But as I say, something that is still subject to lots of change and movement. So moving on to the next slide. Currently, the position has changed as of the 16th of August, which means that for those who are double vaccinated, there is no legal requirement to self-isolate, even if they've been in close contact with someone that's tested positive. So I've bullet pointed there, double vaccinated, under the age of 18, or fall within a medical exemption, and they'll get a note from their doctor confirming that, if that is the case in relation to those. Otherwise, PCR tests are still recommended, but it's not a legal requirement, so it's not something that you can force people to do. However, if it is someone that's coming into the office and working in close proximity to other people, it is something that you might want to think about updating your policies and thinking about what your strategy and what your position is going to be to protect the health and safety of others. But ultimately, if someone does test positive for COVID, there is still that obligation to isolate. So that is where we're currently in. Moving on to the next slide then. That therefore means that as of 16th of August, employees don't have to tell you if they have been in close contact, if they are able to be in close contact, but they're double vaccinated and therefore still want to come into the workplace. So from my perspective, I think one thing that you still may want to think about as employers, if the circumstances and situation still allow it, to then avoid, if someone does have COVID and then it's sort of passing around the workforce, it's still trying to maintain certain things such as social distancing and the perspex screens and those types of things, but for a bit longer until we know and have a bit more data of where things are continuing to go in relation to this. Otherwise, just from a practical point of view, because of where the current legal positions are in terms of having to isolate, test and so on, you still have an exposed workforce. And ultimately underlying it all, you still have to remember that as an employer, you have an obligation in terms of protecting health and safety. So that's just something to think about from that perspective. And so I think throughout the pandemic, you've obviously been used to updating your messages, your policies in relation to that. So I think this is the next step, that if you've not done so, is just then thinking about what your communication is to staff of what you expect of them if they are in close contact, whether you're asking them to say, we would respectfully ask you to stay at home for a period of X number of days just to protect the rest of your colleagues and so on, whether you're still going to mandate mask wearing if there's movement around the office, but not if you're sat at your desk, for example, and those types of situations. But otherwise, moving on to the next slide, one question that we regularly get asked, and sorry, that is probably going on to Joanne's, but before I let Joanne come on, one thing that we regularly get asked is whether or not you can ask those questions and whether you can sort of force people to tell you. So I think this is where I'll hand over to Joanne to tell you a bit more about what the ICO says about collecting that data or asking for that data.
Thanks, Padma. It is definitely something that you need to think about from a data protection point of view, because it's certainly not a free-for-all in this area. The first thing I'm just going to mention is that what you're doing may not be caught by GDPR at all. So the ICO has guidance, and I would definitely suggest that you have a look at the ICO guidance. They've got specific coronavirus and vaccination guidance, and it does change quite regularly. So if you're concerned, and it is quite easy to access, and it is written quite clearly, you know, by all means have a look at the ICO website. One of the things they've said is that if, for example, there is a visual check of somebody's app, or there is a visual check of a letter relating to vaccination status, then that is not something that they consider to be processing personal data and is therefore outside GDPR. So essentially, if somebody just sort of shows you their phone in terms of a QR code on it, they don't regard that as being processing personal data. If you scan it though, or you record it anywhere, in terms of you put it on an HR file or something of that nature, it is processing it and you are caught by GDPR. So it is probably worth just thinking about that. Now, if you are going to be recording it, you do fall within GDPR. Something else that's worth knowing is that vaccination status is health data. So that falls within the special categories of personal data under GDPR, and it's subject to additional safeguards. So you have to jump through additional hoops. So in terms of showing what you are doing is lawful, you have to look under Article 6, which is your general provisions to show that things are lawful, so things like compliance with employment contract and compliance with contract, or legitimate interest. So you've got to jump through that hoop, but you've also got to show that the more limited list of things in Article 9 are also met, and that's not always quite so easy. So two of the things that are very relevant in terms of legitimising and saying what you're doing is lawful is under Article 9, you can say, if you can show that you need to process the personal data for either meeting your obligations under employment law or to take advantage of any rights under employment law, then that's something that might allow you to check vaccination status. So I think if you have got people who are on site, you have got an obligation from a health and safety point of view to keep other people safe. So there's potentially an argument there that if you've got people on site, that you can ask about vaccination status if that's something that you think is relevant in terms of from a health and safety point of view. The other side of it is in terms of establishing a defence to a legal claim or establishing your position in relation to a legal claim. If you are concerned that potentially you've got people on site and other people may sue as a result of potentially catching COVID or something of that nature, you potentially could record some of this information if you felt that that was something that would be relevant in terms of establishing a defence to a legal claim. Now, the thing that you may have got from that theme is it's going to be really, really difficult to ask people about their vaccination status if they're working from home, because you've got nobody to protect in that situation. They're working from home. They are sort of not coming into contact with anybody else. So it is going to be very difficult. I think the other thing that I would say is don't just do it just in case. GDPR does not like just in case collection of personal data under any circumstances. So there's got to be a genuine need for it from a data minimisation point of view. And also, as you've also detected a bit of a theme running through this presentation in terms of be clear about it, in terms of the ICO has suggested that you either amend your privacy notice with staff to explain what you're going to capture and how you're going to use it, or you have a COVID privacy notice to, one, talk about what you're going to do with information in relation to sort of COVID or self-isolation obligations and status and vaccination status, but you do need to be clear with people as to how you're going to use the personal data. So there is quite a lot to think about in terms of vaccination status. But I think the two takeaways that I would say to you, well, probably three things. One, it's going to be very difficult to justify taking vaccination status if people are working from home. Two, don't do it just in case. And three, be very clear about why you're doing it to your staff and how you're going to use it. Right, I'm going to pass back to Padma for a quick canter through. We've not got a lot of time left.
No, we don't. I think thank you to those of you who have joined us. We're probably going to run over about 5-10 minutes, but hopefully, because there is a lot to go through, and hopefully is worthwhile, that we take a bit of time of going through that. So moving on to the next slide then. The other question that I'm regularly getting asked is can we tell our staff that they need to get a vaccine if they want to come into the workplace or to continue to be employed by us? And as I go on to the next slide, looking at a no job policy in relation to moving forward. Now, as I've put on the slide, we've currently got emerging data that means fully vaccinated people is more that they are less likely to be as poorly if they do catch COVID, rather than completely eliminating them from catching or transmitting COVID. So this goes back to my original point of, even with vaccination, still think about, from a health and safety point of view, whether you're still going to keep certain COVID measures within your own workplace, such as distancing and how many people are in the office at any one time, because of that data that's coming through. But ultimately, you cannot force someone to have a vaccine, especially because different people may have different reasons for not taking that vaccine, whether it be religious, medical, or otherwise. So that's where we're currently at, save for the care sector, where the government have come out and said for the care sector there will be a requirement come November that you must have a vaccine in order to carry on working in close proximity to those that are classed as vulnerable. We may start seeing some of those boundaries being expanded, whether it be into the healthcare sector, GP surgeries and those types of things. But for now, it is very much limited to that specific care home staff. So just to again reiterate, if you are going to ask people about that information, or I'll have certain policies around it, ultimately you need to be able to justify it. But as I say, at the moment, there is no legal basis upon which you can force people to have that vaccination other than that care sector exception. So moving on to the next slide, looking at the no jab, no job policy that Gary Pimlico Plumbers came out right at the beginning of the vaccinations coming out to say, this is what my workforce are going to be. Does that really work in practice? Well, I think it again goes back down to the same types of things that Joanne was talking about, of what kind of work you're doing and what the purpose is that you are trying to achieve. Because as I put on the bottom of that slide, otherwise there is a risk of indirect discrimination claim, in that people might say, well, actually it's because I'm medically exempt, or I've got a philosophical or religious reason, and your mandatory requirement of me having a vaccine is disproportionately impacting me because of my race, disability and so on. So at the moment, where the current law stands is that unless it's in that exception, you shouldn't be forcing people or setting boundaries around that. But the ways around it in terms of protecting your staff is continuing to think about other health and safety measures that you may have in place. So moving on to the next slide then, as we've put on there, we've regularly put out newsletters. As I mentioned, do please get in contact with Joanne, Hannah or myself if you do have any questions, and do link in with us, because we regularly do post updates in relation to that. Throughout today's session, we've mentioned on several occasions in relation to the employment law bulletins that we do, especially in relation to coronavirus and the regular updates and changing landscape in relation to that. If you're interested in that, on the questionnaire form, that the link should appear again in the chat box, please do complete that, and please do put that on there, and we're more than happy to answer those or send those questions, those questionnaires and things that we put out there to you. So moving on to the next slide then. I don't know, Hannah, whether there were any pressing ones, one or two that we can probably do now, but otherwise I can see that there's quite a lot that have come through. So if you've not answered them, we will come back to you separately on an individual basis. So please do leave your details with us and then we will provide you with that information. Hannah, was there anything, one or two questions that were particularly interesting that for everyone to hear?
Yeah, there's one we've had in when you were talking about vaccination status. So if someone's a site-based worker, not someone that's working from home, could you ask for proof of vaccination to establish if they need to self-isolate?
I think you can, because I think back to if it's a legal obligation not to have anyone on site who's required to self-isolate, then I think in terms of establishing a defence to any claim that you've illegally had somebody on site, if somebody phones up and says, you know, I've got coronavirus and I've not got to self-isolate, then I think you probably can say to them, well, on what basis are you not self-isolate? No, you've got coronavirus. Sorry, that's wrong. Completely ignore what I've just said. In terms of if you have been in close contact with somebody who has coronavirus and I'm not required to self-isolate, then I think you can say, well, on what basis? Is it because you've had, you know, you're double jabbed and therefore you can take advantage of that exemption? But I think you need to understand if people are saying if they've been in close contact and they're not self-isolating, why they're not self-isolating, and mark that down.
Perfect. One final one we've just had in is if a company requires staff to carry out lateral flow tests or otherwise they're not allowed on site, is that something that they can still ask their employees to do?
I think if you've got a legitimate reason because you are concerned about the type of work they do and it requires close contact, then using that as a health and safety measure and you've thought through why you need that lateral flow test, then I think it's still fine to ask for that. Going back to points that Joanne was making earlier, you then need to think about processing that data, keeping that data, and how long you're keeping that data. If you're then saying, do a lateral flow test, and then we're going to record the data to satisfy ourselves that you're negative. But yeah, if it's a mandatory role that requires close contact and you've got legitimate reasons as to why you're asking it, then I think you should be fine asking for lateral flow tests. Okay, well, thank you everyone for watching. Our contact details are on there. As I say, if we've not been able to get to your question, we will come back to you. And please do fill out the feedback forms because that's really important to us to understand the types of issues that you'd like to hear from us. And as you can see, there's lots going on in terms of our quick canter through and hopefully we'd like to see you again soon. Thank you.